The broadcast is now starting. All attendees are in listen-only mode.
Hello, good afternoon, everyone. I am Marion Walsh. I'm an attorney at Littman Krooks with 20 years of experience in education law, and I wanted to thank you for joining us today. We're going to be talking about the Endrew F case, a United States Supreme Court case decided on March 22nd, 2017. So it's brand new, and we're going to talk about the impact of the case and what it says and how it can help your child. And I wanted to ask you, if you have any questions during this webinar, to please use the chat box and write them out, and I will attempt to answer them during the broadcast. We can make this as deliberative and interactive as possible. So again, thank you for joining me, and congratulations on surviving to the end of the school year. And we'll get started on the case and the background. Now, the first thing to remember is that this Supreme Court case was decided under the Individuals with Disabilities Education Act. This is a federal statute that was enacted in 1973, and it creates an affirmative obligation for every public school district to provide every child with a free and appropriate public education. And that is what we're going to be discussing today. What is a free, appropriate public education? And when we talk about an affirmative obligation, we mean that the district has a duty without the parents taking any steps to identify students with disabilities, to serve them, and to provide an appropriate IEP. And the IDA does affirm national policy to improve equality for opportunity, full participation, independent living, economic sufficiency for individuals with disabilities. And there are substantial resources devoted to this, both from the federal, state, and mainly local school districts, to ensure that students with disabilities have an appropriate education. So it's an important law, an important part of our statutory framework, and to serve the most disadvantaged students in society. So Endrew F was decided this year, and this is the first time in over 35 years that the Supreme Court has really discussed what a free, appropriate public education means. So it's really important to note that, because these cases don't come around very much. And when the U.S. Supreme Court decides something, this is the rule of the land and the rule of that every district has to follow. Now, the Supreme Court does speak in very broad strokes, so it's really going to be up to each district, each hearing officer, each state review officer, and each federal court to decide how to interpret this case. And it's really important for parents to understand what this case means, because it's not an automatic change for each child. So I'm going to go back to talking now about the last time the Supreme Court decided on what a free, appropriate public education is. It was actually almost exactly 35 years ago that the Supreme Court ruled that a student with a disability receives a free, appropriate public education, a FAPE, when a program is reasonably calculated to enable a child to receive educational benefits. And you can see that's really a relatively low standard. Reasonably calculated does not set a very high bar for what is provided, and to receive educational benefits, it's a relatively very broad term, actually. So in this particular case, this court had ruled that the school district had met its obligation to provide a FAPE to the student who was named Amy Rowley. She was a first grade student, and she only had residual hearing, and the district did not want to provide a sign language interpreter one-to-one. They believed that their FM system was appropriate for her. And the parents really said that she needed a sign language interpreter, not just to make progress academically, but really to communicate with her classmates and really have a fully integrated experience. But the school district disagreed, and when the parents filed for a hearing request, they still denied it, and eventually this case went all the way up to the United States Supreme Court. So the student was attending school in a general education class, and she was advancing from grade to grade. And in this ruling, Justice Rehnquist, who was wrote the opinion, stated that this was a limited ruling for a student who was progressing well in the general education setting. And I'm giving you this background on the 1982 case because the Endrew F case discusses a lot about the Rowley case, and it's important to know what the Rowley case says because it has been setting the standard in this country for 35 years on what is appropriate. So for many years, there was conflict between the various courts on what standard to apply to students with disabilities. We all know that it's an IEP reasonably calculated for educational benefit, but what level of educational benefits were school districts obligated to provide? Did it have to be meaningful, or was it merely more than de minimis? And de minimis means just a very tiny, small amount, almost the smallest amount you can imagine. So if it's only a little bit more than the minimal, is that enough for an educational benefit? And that is what the United States Supreme Court was struggling with. So in Endrew F, this case actually started in approximately 2011, and Endrew, he is a student with autism. He attended the Douglas County School District in Colorado, and he went from pre-K to 4th grade, so he'd been there for some time. And the school district did create IEPs, but his parents believed that he was not making educational or functional progress by the end of 4th grade. He had very significant behaviors. And he would scream in class, run away from school, climb on furniture. And because he was a student with autism, these behaviors were part of his disability, and he could not really obviously learn when his behaviors were not appropriately addressed. So the school district was making some efforts to address his behavior. He had a functional behavior assessments. He had behavior intervention plans, but these plans were really not working because his behaviors did not improve. And his teachers all described him as a humorous student with a sweet disposition who showed concern, but as noted, they were not able to get these behaviors under control. So the parents did remove him from the public school, and they placed him in a private school for his 5th grade year, and it's called the Firefly Autism House, and he did a lot better there. It was a smaller setting, and it was geared specifically for students with autism, so they were able to provide more individually tailored services. And then still the district kept trying, and 6 months after his enrollment at Firefly, the district maintains an obligation to develop an IEP even if parents remove a child into a private school, provided that the parents are still seeking a free appropriate public education through the district. And parents should know that the Endrew F case is a tuition reimbursement case, and the IDEA, Individuals with Disabilities Education Act, does give parents the right to seek tuition reimbursement for a private school if the school district denied the student a free appropriate public education. This is not a simple process. You can see in the Endrew F case it took many, many years, but there are 3 prongs, and many parents are able to be successful if the district denies free appropriate public education. So the 3 prongs are: the district must deny the student a free appropriate public education, the private school must be appropriate and provide individually tailored services, and equitable considerations must support the claim. Equity means that the parents have to give the district the right notice, they have to provide consents for evaluation, they have to cooperate. And I view equities as also putting obligations on the district to treat the parents forthrightly and to give the parent input and to follow the IDA. But a lot of courts just really look at the equities as far as how the parents act, because, for example, if a parent does not provide consent for the district to evaluate the student or to provide services, it's going to be difficult for the district to provide the student a free appropriate public education. So these are the 3 prongs of tuition reimbursement, and the Endrew F case is really only getting to the first prong, which is, did the district provide Endrew F a free appropriate public education? There's no discussion now of the second prong of whether the private school is appropriate. But in any event, the parents did reject the second IEP, and they then filed a complaint, which is a due process complaint. That's an administrative complaint that goes to a hearing officer or a state review board in Colorado, and it seeks tuition, they sought tuition reimbursement from the school district to pay for Endrew's private placement. And in this case, in Colorado, there's one tier of review, so they filed theirs with the Department of Education. Now, in New York, we have two tiers of review. Parents, if they are disagreeing with an IEP, they first file with the school district, which gets assigned to an impartial hearing officer, and there's an administrative hearing. And then if parents of the district disagree, they can file to a second tier for an appeal to the State Office of State Review. It's a state review officer. And then the state review officer has to give a decision within 30 days. And then it goes to federal or state court. Most parents do file in federal court on appeals, but state courts can also hear the complaint. So in Colorado, there is just one tier. They filed a due process complaint with Colorado Department of Education, and impartial hearing was held before an administrative law judge with the Colorado Office of Administrative Courts. Now, this administrative law judge held that the Douglas County School District had met its obligation to provide Endrew with a FAPE because he made some measurable progress toward his goals. And that was the question: what is some measurable progress? And the parents claimed that the IEP was not reasonably calculated to enable Endrew to receive educational benefits. So the administrative law judge didn't address the issue of how much, but it just held the district did provide a FAPE for Endrew despite the fact that his behaviors were not improving. Now, so then the parents then appealed in the Endrew F case, and they sought reversal of the administrative law judge's determination, and they filed suit in the federal court, and that would be the district court in Colorado. And the district court did affirm the administrative law judge decision, and they gave due weight to the decision of the administrative law judge. And what they said was that Endrew's performance under past IEPs, they acknowledged it didn't reveal immense educational growth, but they concluded that the annual modifications on his IEP objectives were sufficient to show a pattern of at least minimal progress. So they affirmed, and then they, the parents then appealed to the next level of federal appeal, which is the 10th Circuit, the Court of Appeals. And the 10th Circuit interpreted the Rowley case, going back to Rowley, to establish a rule that a child's IEP, as long as it's adequate, as long as it's calculated to confer an educational benefit merely more than de minimis. And again, not every circuit court in the country does this. In the circuit courts, the country is divided into circuits. New York is in the 2nd Circuit. Colorado is in the 10th Circuit. As I noted, there is a split between the circuits. New York, in some cases, they seem to follow the de minimis, more than de minimis test, but in other cases, they require meaningful benefit. So New York is a little bit all over the place as far as what courts have held. I have seen federal courts use both standards, but in general, the standard seems to be a little higher than de minimis, because some cases do use the word meaningful, that a student must have meaningful access to the curriculum. And because there's a lot of litigation in the 2nd Circuit, the standard is sort of de facto higher because you have a lot of people advocating and a lot of cases. But in Colorado, this 10th Circuit concluded the IEP was reasonably calculated to enable him to just make some progress. So they basically affirmed and held that its school district had met its obligation to provide a FAPE to Endrew. And then if a court finds that a district provided a free appropriate public education, then they don't even have to get to the next standard, the next prong of whether the private school is appropriate, or the third of whether equities support the claim. So the parents at this point were denied their claim for tuition reimbursement. So It's, as I said, this is usually the end of the line for an appeal, because the Supreme Court very rarely takes cases on a certiorari, which is the petition to the United States Supreme Court. But in this case, the parents did petition the Supreme Court to grant certiorari because, as they noted, the courts of appeal are in disarray on the matter of what constitutes a free and appropriate public education. And in this case, the United States Supreme Court actually granted the petition for cert to resolve the conflict between the circuits. So it wasn't just that they found necessarily Endrew F's case so compelling, because there are a lot of tuition reimbursement cases, and it wasn't that much different than a lot of the others. But this particular case, because of the de minimis standard, and the attorneys were able to show the court that there was needed guidance from the highest court in the land on what the level of benefit, educational benefit, means, what that term means. So it did grant cert to resolve the conflict between the circuits. So that was in September. And as noted, the case was decided in March. So on March 22nd, 2017, the Supreme Court held in favor of Endrew F, and the decision was unanimous. Every justice signed on, and this was at the time when the Supreme Court was 8 individuals, not 9, and Chief Justice Roberts delivered the opinion of the court. And the Supreme Court stated that to meet its substantive obligation under the IDEA, a school has to offer an IEP reasonably calculated to enable a child to make progress appropriate in light of the child's circumstances. So that part is not that much different than what the law has been, but the court was very clear in saying this standard is more demanding than the merely more than de minimis standard applied by the 10th Circuit. So it was a very clear rejection of what the 10th Circuit had said. And it's really important. It's important to note, as far as the current court makeup, Justice Gorsuch, who just joined the court, was from the 10th Circuit, and he had actually applied this de minimis test in past cases. And he explained that during his confirmation hearings, basically by saying, well, that was the law of the circuit at that time, and I don't necessarily still agree with it. So he viewed himself as bound by precedent. But this was stated, there's nothing, the main thing to take out of this case is that the standard has to be more demanding than the merely more than de minimis standard. And it sounds to us as parents and parent attorneys as sort of a no-brainer that of course it has to be more than just a minimal amount of progress. But that has not been the case in a lot of circuits, and certainly not in the Endrew F case, because sometimes students with disabilities, unfortunately, don't make a lot of progress. And if in the past, if a district was showing that they made a lot of efforts, made some changes, changed goals, and the student made a tiny bit of progress, courts have held that to be sufficient, because there's no guarantee of any certain level of progress. So that part of the ruling is very, very significant for students with disabilities and their parents to be able to advocate that. It's no longer appropriate to say this tiny bit of progress is all we can do and appropriate. So so the court, in its decision, they basically reiterated the Rowley standard. They did not reverse the Rowley case, which we talked about before. Some of us were hoping that the court would almost reverse Rowley, because in my opinion, as an attorney for parents and students with disabilities, I believe the Rowley case was not really sort of finely tuned enough or accurate, because while Amy Rowley was making progress through her grades in the general curriculum, she was only in first grade, and you know, the grades are very subjective. It's hard to tell what a passing grade in first grade really means, because it's very subjective. And the student in that case, she couldn't communicate with her peers. She was really isolated, and I think maybe under Title II of the ADA, or that there could be an argument that she really needed that sign language interpreter for her communication. And remember, Rowley was decided also before No Child Left Behind, which is now the Every Student Succeeds Act, before we had standardized assessments, before we really knew as much about how students progress. So I was hoping that there would be a re-examination of Rowley, but there was not in this case. The court said that in Rowley, the student was progressing smoothly through the general curriculum, and they really distinguished it from the Endrew F case, because Endrew F was not progressing through general curriculum. He was not in a general education class. So on Rowley, the court said that if it's not a reasonable, in Endrew F, in interpreting Rowley and distinguishing it, the court said if it's not a reasonable prospect for a child to progress through the general curriculum, his IEP need not aim for grade level advancement. But his educational program must be appropriately ambitious in light of his circumstances, just as advancement from grade to grade is appropriately ambitious for most children in the regular classroom. So, so they were sort of drawing a parallel. Look at how Amy Rowley progressed, where she was getting good grades and in the general curriculum, and a student like Endrew, who was not in general education and in progressing from grade to grade and getting good grades, he was in special classes. The program needs to be appropriately ambitious. The goals may differ, but every child should have the chance to meet challenging objectives. Now, all of us know in special education that it's not always a clear-cut, a bright line rule on who's in general education, who's in special education, who's progressing in the general education curriculum, who is not, because there's a lot of in-betweens, but I don't think the court quite realized that. I think they didn't view it as a bright line test, but they did say that for a student in special classes, the standard has to be appropriately ambitious, but for a student who's in general ed, it's still the same standard. It's grade level advancement if the student is progressing from grade to grade and getting good grades. And some of the problems I see with that are some students are maybe progressing from grade to grade, but may not be really succeeding. For example, they may not be able to attend school. They may just be able to just get the good grades based on sort of teachers doing modifications, but really may not be learning the curriculum. So there's a lot of ambiguity here and a lot of work to be done in analyzing how this case is going to play out. But it's important to note that the court did not really develop a bright line rule. They said that we will not attempt to elaborate on what appropriate progress will look like from case to case. The adequacy of a given IEP turns on the unique circumstances of the child for whom it was created. And that language, the adequacy of an IEP turns on the unique circumstances of the IEP for whom it's created, that can be used in many different ways. As a parent and a parent's attorney, you would argue that the school district has to look at the unique circumstances of your child, meaning that your child is really capable of more than the school district says they are. For example, you may have a private evaluation or an evaluation from a neuropsychologist that says that your child pinpoints what your child's disability is and then says what specific interventions the child needs in order to make more progress than he or she is making in the current setting. So you look at those unique needs as what is needed, what to make the child progress more. That the district may do it the other way, and they may be saying, well, you have to look at the unique circumstances. He or she has a significant disability and is not capable of mastering certain work. So parents and districts are going to look at this language very, very differently. And you should, all parents should know that the Rowley case did specifically state that a district is not obligated to maximize a child's potential, which is a very disappointing statement, but that is still the rule of the land, that there's no requirement to maximize potential. But of course every parent wants to maximize a child's potential, and even school districts would like to. They're just not obligated to for a student with disability under the law. And that was sort of a recognition from the Rowley case, just due to public resources. It's not always possible to do that. But parents can still use this language on the unique circumstances to really advocate and push for a more finely tuned, more specifically designed and uniquely tailored program to ensure the child is receiving the right services and that the right evaluations are done, because sometimes students with disabilities are not sometimes, but are often very complex, and a district is not going to really understand what is what the child's specific needs are, even what their level of functioning is. For example, if they're nonverbal, it can be hard to tell if the school district does not have specially trained staff. So a little more on Endrew. This is getting into a little bit more of what the court said. And on the standard of review, parents should all know that when a case does go to federal court, federal courts will still give deference to administrative proceedings. And the Endrew F court said that a reviewing court may fairly expect those authorities to be able to offer a cogent and responsive explanation for their decisions. And that's not really too much different than what is happening now, because the school district at the hearing will present a case, and the parents will present a case, and the hearing officer will decide on it. And the court will look back at that whole trial, or the administrative trial, to determine whether the decision from that trial was appropriately decided. They're not going to do a whole new trial at the federal level. So it has to be cogent and responsive, and the Endrew F court did look back on those administrative decisions and said they were not appropriately characterized. I just want to go back before I turn to the next slide, if there are any questions about the appropriately ambitious standard, or any questions about the IEP turning on the unique circumstances of each child, because it'd be helpful to get input and to make sure that that is understood, that appropriately ambitious standard. Okay, if there are no questions, I will move on a little bit more about Endrew. The bottom line is that every child should have a chance to meet challenging objectives. And the Supreme Court noted that the students, teachers, and parents would know best under the child's unique needs and circumstances. Now, there is some language in the Endrew F case which does state that they're not only sort of giving deference to parents, but giving some deference to teachers and schools. And that's a little bit concerning, because they're basically saying the courts don't always know what's best, but they are saying that there was a point at the end of Endrew where it says deference is based on the application of expertise and the exercise of judgment by school authorities. The IDA vested these officials with responsibility for decisions of critical importance to the life of a disabled child. And then the next line says the nature of the IEP process from the initial consultation through state proceedings ensures that parents and school representatives will fully air their respective opinions on the degree of progress the child should pursue. So it's recognizing there's often tension or a dispute between parents on the nature of how much progress a child is appropriate, or whether the program is appropriate from the school. So it's not really a bright line test. While it is a victory, this case is a significant victory for parents, and it can be used really to revolutionize the way school districts will approach IEPs. It's still a very vague standard, and it does give some deference to school authorities. So because it's a Supreme Court, that's a very vague standard, but the one thing that is clear from the decision, which you should take away, is that school districts can no longer satisfy their obligation to provide a free, appropriate public education by creating an educational program which facilitates only slightly more than trivial progress. So that very depressingly low standard is no longer the law in any district in the country. So that's probably the most important part of the decision. So that is the main takeaway, and then the other part of the takeaway is what you can do with it. So just practically, what did the case mean for Endrew F? It's not an automatic victory for the parents. There's no tuition reimbursement. The case actually may settle at this point. We don't know. But the case was remanded back to the lower court to determine whether the student's educational program was appropriately ambitious in light of his circumstances. So that is what the district court in Colorado now has to decide. And they may find that it was, and they may find that it wasn't. And then if they find that it was not, they have to then decide whether the private school, the Firefly School, was appropriate for Endrew. It does sound like from all descriptions of it that it would be, because he did make progress there and it did provide especially tailored services for his unique needs. And it does seem that equities would support the claim, but we don't know yet. So, so the case had to go back to the federal court. Now the meat of this program now that you have some understanding of what Endrew F means, is how can you advocate for your child what an appropriately ambitious program looks like. And for each child, obviously, this is going to be a very different standard and a different way of looking at it and a different perspective. But either way, you should be looking for challenging academic standards and curriculum and exposure to grade level standards for every child with a disability. And this has been the law of the land and the fundamental tenet of the IDA for years, since its inception. So, and was even further reinforced in 2004 when the IDA was reauthorized. So, so every child should have challenging academic standards, and it's important to look at that through both the goals and also through whether the child is, what is the child actually learning. Now, if a child is in special classes, the special classes should still be aligned to the general curriculum. There may be some modifications, but there should still be alignment to the general education curriculum, which in New York is the sort of modification of the Common Core, and there are rigorous ELA standards, rigorous math standards. So, so there should be high expectations. That's the first thing. Now, it's important also to look at the least restrictive environment, because the Endrew F case did again emphasize the importance of the least restrictive environment. And this means access to typically developing peers, general curriculum, and community experiences. So if a student is in a special class, there again should be high standards, and the student should have access to typical peers. And a lot of districts are not always able to do this to the extent that they should. The least restrictive environment can be a difficult issue, because especially in New York, we have a pretty rich continuum of programs, which is a positive thing. So we do have, a lot of schools have special classes, they have special programs for students with certain disabilities, but these special programs cannot be so restricted that there's no access with typical peers. And in some cases, it's important to advocate that even if your child is in a special class, perhaps there should be at least one day a week where he or she is not only having interaction with typical peers at lunch and at recess and in specials, but perhaps in an academic class, because there's a significant difference between the way a general education class is conducted, the richness of curriculum, the language, than how a special education class is conducted. So, so that can be something to advocate for your child if it's appropriate. Now, the least restrictive environment does mean something different to each child. So by the same token, it doesn't mean that a school district should just place a child in a general education class if he or she has significant disabilities without the right supports. So there have to be supports and modifications, and there has to be a way to ensure that the child can actually can learn and make progress. And a lot of school districts don't always honestly want to make that effort to ensure the child does get the right supports in the least restrictive environment. They may need a one-to-one aid, for example. They may need significant modifications to the curriculum, and each case is going to be different. It's not, and it's also not fair to place a child in the least restrictive in a general education class if they may need, say, a therapeutic environment. So this concept of least restrictive environment is going to be different for each child, but it's an important part to advocate for. Now, I think also it's important to look at a child's splinter skills. For example, a child may not test well on IQ tests. They may be generally have relatively low functioning, but there may be some area they really can shine and look and, you know, have a significant strengths. And school districts unfortunately tend to dismiss these skills, whether it's music, whether it's math calculations, whatever it is, but they should be really used to build a program. So students should be able to deploy skills to compensate for weaker areas. And for every student, whatever their interests are and their strengths are, districts should be able to really build on these to build a program around it. And that's when students transition eventually into post-secondary programs. That's sort of the essence also of self-direction, that students should be able to direct themselves and look at what their areas of strength are, what they want to do, and build on these skills. So for example, perhaps a student maybe have lower skills in verbal but very high in math. Perhaps they may want to try a general education math class to at least be exposed to it. So again, it's important to know, it's also important to know the learner skills. So the evaluations here in the Endrew case are very important. The Endrew F case did not really discuss evaluations. They did on the Endrew F case did discuss FBAs, which we're going to talk about in a minute, which are functional behavior assessments. But evaluators, including school district evaluators, should really try to administer tests in non-standard ways to see if certain accommodations will allow students to demonstrate relevant skills. And the student's ability to perform with accommodations is real and relevant. So a school district can't just say to a child, you know, you're non-testable, we can't even get a score. You have to work with the child to really figure out, again, what the strengths are, and also, I think, what the disability is, because school districts often do rather sort of broad level testing. They just do one IQ test, one look, in addition to other assessments such as speech language, such as OT, such as PT, such as classroom observations. But they should be able to administer evaluations that really do pinpoint what a child needs and what the specific disabilities they can address, not just sort of do broad-based. Now, if a parent disagrees with a school district evaluation, they are entitled under law to an independent educational evaluation, that's an IEE, at public expense. So the district would have to disagree with the district evaluation, and then they would go through a process to seek an independent education evaluation that the district would pay for. Now, it's not sort of, it doesn't mean that every parent can go to the evaluator of their choosing. Districts often maintain a list of their approved evaluators and a certain budget that they will give parents to find an independent evaluation. It's not a carte blanche just to have anybody evaluate, although you can work with the district to find someone that you deem appropriate. So it's important to get the right evaluations. That is really the essence of what an IEP is, and what you can't build a good IEP without good evaluations and good knowledge of what your child's needs are. There are neuropsychological evaluations which can be completely game-changing for children, where you really can pinpoint what is really going on with the child, because some children don't always show what's happening inside, and you really have to know from really fine-tuned testing what's happening. And for example, neuropsychs, you can get them through insurance sometimes, and some districts will do it in complex cases. So it's worth pursuing that, particularly if the district is really misunderstanding your child's needs. As I noted, the Endrew F case was not a case about evaluations, but it was very clear once the student was in the right setting that he really was able to change his behavior. And that is really what every parent's goal is to find that placement and that IEP that is going to change things for your child, to really help your child make the appropriate progress, make what we would call meaningful progress. So those evaluations are really important to that, and the school districts are not going to see it the same way. Obviously the school district is serving thousands of children, and they're going to say, okay, is my program appropriate? How is the child doing? But they're not going to really look for that the placement that is going to really be game-changing or really fine-tuned to meet the child's needs. Okay. So as far as advocating for appropriately ambitious, if your child has behaviors, you should insist on a functional behavior assessment and a behavior intervention plan. And this should be a plan that works, and it should have data. It doesn't mean just because the district writes up a plan that it's appropriate. It has to really work. And I think it's also important that if your child has any kind of behaviors that interfere with learning, to insist on a plan. And that includes internalizing behaviors, inattentive behaviors. School districts will often only develop functional behavior assessments if a child is really acting out. You know, maybe they're physically violent or verbally disruptive, and then those are the children that, of course, the district is going to develop a plan for. And Endrew did have externalizing behavior, so the district did a plan. But even when in Endrew F case, when the district redid its plan, even after the parents had removed him from the private school, they really just did the same plan again. They never did not make improvements. And there's a lot of case law in the Second Circuit now on the importance of an FBA. The Second Circuit does consider the lack of an FBA a procedural violation, and it really insists on having a plan that works. And the district can't really delay having a plan, for example, to wait till the student's in a new placement. They really have to develop a plan immediately if a child is having behaviors, which it could include, again, internalizing behaviors. It could include not going to school. Districts need to work with parents and figure out why the child is having these behaviors of avoiding school. That's a behavior in itself. There are avoidant behaviors, so it's not just externalizing behaviors. Now, it's important with communication skills for students who have difficulty communicating, particularly for nonverbal students, to have an appropriately ambitious program. And the Endrew F case was not about Endrew's communication, but there are students who do have difficulty communicating, and these plans have to be developed, and districts may need to try many methods to see what works and then use them. The district can't just throw a device, assistive technology device at a student and say, here it is, you can use it, and let's see how it works, and then not change it if it doesn't work. There has to be training, there have to be the right programs, and for the most significantly disabled students, it's very important to enable self-determination so the student can express preferences for people, activities, foods, and has to be equipped to participate in meaningful activities. So this is important, especially as children become older and emerge into adolescence, because sometimes a lot of students do develop behaviors, particularly students with autism, because they're so frustrated by not being able to communicate properly and not being integrated. And so if you can get the right means to communicate for students to be self-advocates, to express, the student then can make the appropriate progress both academically and functionally. So look at those communication skills. Now, functional skills are also very important. We're looking at whether a child can demonstrate skills with decreasing levels of support, and this is not any less important than being able to demonstrate more complex skills with a constant level of support. So again, especially as a child ages and becomes an adolescent and then eventually an adult, the student should be able to do things with decreasing levels of support. Now, this doesn't mean that the school just cuts it off without giving the right supports and training. They have to work with the child to make sure that he or she knows how to demonstrate these skills and work on them. Now, there are other areas also. For every child, there's a different way to advocate for what's an appropriately ambitious program. And that's why understanding this case is so important for parents, because what is appropriately ambitious for your child is going to be different than for what another child is. Some parents may want their child in a general education setting. The district may think they need to be in a special class, and the child may really need the exposure to typical peers. For other children, it may be that they do not thrive in general education, need to be in a smaller setting. For some children, it may be the district is not evaluating them properly. The parents need to push for evaluations. But either way, you should use this language, appropriately ambitious, and an IEP catered to a student's unique needs, to advocate for what you deem appropriate for your child and what your child needs. So the other important aspect of this is at transition time, when the student is getting transition services, make sure the student's transition services plan and the plan for post-secondary activities is appropriately ambitious, because that is going to be the important time when your child either transitions to college with support, to to workplace, to an OPWDD setting, could be to a group home, it could be to a day hab. There's a lot of different efforts. So, so it's very important to think about what's appropriate for your child. So I have some cases that say what has happened with Endrew F so far. There's not a revolutionary change in New York law based on Endrew F yet. Remember, the case was only decided in March, so courts have not had a chance to absorb this yet. And as I've noted throughout this presentation, it's not as though this Endrew F created this new standard that courts can automatically apply and say it changes cases. This case is going to have to come up through the channels, starting with parents advocating, starting with school districts changing programs, starting with impartial hearing officers making decisions based on it, then state reviewed officers making decisions, and eventually getting up to the federal court reviewing those decisions. So it's not something that has changed the law at this point. The most recent case citing Endrew F, I'm sorry, was the RB case, which is from the Second Circuit, and that was just a simple, the court did vote for the district and affirmed an SRO decision. And it really decided Endrew F as sort of, this is the new standard, but it did not really apply it. Now, the AG case was for a student who had dyslexia and was in general education, so it's interesting that the courts are still citing Endrew even for students who are in more general education settings. But in this case, again, the judge deferred to the IHO and SRO that the student made progress, even though the parent claimed that he ended third grade at level N and tested at level N. Harrington case, this is really only a funding, and the MN case, again, the court just cites the case but defers to the SRO. So there's not been a change in the law yet through Endrew, but as noted, you're going to have to, as parents, make the changes and be the advocate for your child. So out of state, there are a few other cases citing Endrew. The Davis case, it does give a pretty good analysis for a student with ADHD, and in this case, the court does affirm an IHO decision. It gives some analysis on what an appropriately ambitious program looks like. But in general, there has not been a significant change in the law. And here are a few more cases that have cited Endrew F. Okay, so at this point, we're coming to the end of the webinar. I do want to take any other questions that people have and also invite you to submit anything or contact me if you have anything else, because this is an important case. It's going to have significant repercussions in our future, and I view it as really revolutionary, but it's going to take a lot of work. Okay, so I don't see that we have any questions. We're ending a little early, but if you have anything you want to add or ask me, you can email me here. My email's here, mwalsh@littmankrooks.com, or you can call our phone. This is one number here, but it's also 914-898-2104 is my direct line if you have other questions. All right, well, thank you all for joining, and I wish you all a very happy end of the school year and a wonderful summer. And please contact me again if you have any questions. All right, take care.